Good evening. The outcome has already been revealed to me. I was once again right. Not an unusual occurrence, surprisingly enough. But we're going to go over this. Wait a few minutes, just chill for people to filter in, I guess. It's kind of weird. I remember when I first became a lawyer, man, I had all the time in the world. You work 9 to 5, go home, the rest of the day's yours. Now, the longer I've been an attorney, the more of my own clients I pick up, the more of my own work I have to do, and I have to work it around working for 2 other law firms. So I got long days. I usually leave out of here around 7 in the morning. I usually get back here. Well, tonight I got back here at 8 o'clock. But here we are. Let's see if Chilli learned any lessons. Oh yeah, visit.
The Honorable Judge Zimmerman presiding.
You.
Please be seated. Come to order.
I intend to add fair use to this.
All right, Jose de Castro, 23 CR 013015.
Good morning.
Good morning.
Chris Prosecution on behalf of Mr. Castro. He's present.
Nice to see you, Chris.
I have a new attorney, Christopher Oram. ORAM Nevada attorney. We got Christopher Oram Law Office. Over 25 years of experience. He will fight for your freedom. Nice, clean website. "24 years.
You say something to me?
I'm live streaming. Admitted to the United States Supreme Court. Well, boy, howdy. Boy, howdy.
State Farm number 11064.
All right, this is your motion.
Yes, Your Honor. First of all, I've had a chance to watch the video of the trial. I watched Mr. DeCastro come into the courtroom in an extraordinarily disrespectful fashion and refer to the marshal in the most inappropriate way. I then saw some other things that I consider very poor in the courtroom. And Mr. DeCastro was convicted. He is given 6 months in jail. One thing I know he's going to do today is for no other purpose, no matter what your ruling is. He wants to
Try hard, squeeze those tears out, brother.
If he'd say sorry.
Oh, I gotta listen to what the attorneys say, but this is good. Oh, Chilli, you're acting. It's hard to believe why you were not ever a Power Ranger, even though you were. All right.
I saw some other things that I consider very poor in the courtroom. And Mr. DeCastro was convicted. He is given 6 months in jail. One thing I know he's going to do today is for no other purpose, no matter what your ruling is. He wants to say sorry. I've asked him if he'd say sorry to the court. I understand that.
So this is a good tactic. You want, well, showing remorse is generally a good thing. That it's usually better if you show remorse kind of from the get. Turn off night mode? No. If you show it from the get, you're a human. The judge is human. What's the judge going to think? I saw you being like, hell yeah, I totally want to do this. Yeah, I intend to do it. I mean to do it. And then you spend a couple days in jail. What is it, a week or so in jail? And you come out, I'm crying. I'm so sad. Oh, I'm so contrite. I'm going to say sorry. Criminals are like 5-year-olds, and judges are like the parent who's already had a brood of children and understands what the 5-year-old is doing. Like, I mean, it's the right tactic. It's the right tactic. It's really all you can do. It's just like, it's a day late and a dollar short. You can't put the horse back in the barn. You know what I'm saying? Like, you should have done that a while ago, brother. Like, you should have done it a while ago.
You may see it as that he should have apologized to the marshal. I don't see the marshal in here that he did this. One thing I would note for the court is that the issues that I saw seem to be significant constitutional issues.
Like, and Chilli's acting is just fucking terrible. It's just fucking terrible. It's fucking terrible.
The court addressed it, but what I did notice is that this should have been really briefed beforehand on First Amendment issues, so the court could have had that. That's no fault. I think it just should have been done beforehand. I also know.
So it sounds like he might be setting up an inadequate assistance of counsel defense.
Noticed that at time.
I mean, for not defense, but inadequate assistance of counsel grounds for appeal.
Sentencing, the state asked for a suspended sentence, but Mr. Castro just pushed it, and I see reasonably agitated and irritated the court into causing a sentence that is now 6 months.
Whether or not Chilli irritated and aggravated the court, I don't think it is, generally speaking, a good idea to say your honor got triggered into making a bad ruling, because that's essentially he's saying it in a soft voice, but he's saying your honor got triggered. I don't think that's generally a good approach. I could be wrong. I mean, this guy has 24, 25 years of experience. He's argued in front of the United States Supreme Court. I haven't. He probably knows something I don't. It's not a tactic I would take.
This man, from what I can tell, Your Honor, has no prior.
But I want to caveat this. If I was put into his position, you got to take some tactic. And, what are you going to do? Like, you could do nothing and you get nothing, or you could try. And so far he's trying to do my client is remorseful and sorry. And he's trying the state only wanted a suspended sentence. And if the parties really both want a suspended sentence, that your honor should, not let your honor's feelings get injured, and increase the sentence.
Felony convictions whatsoever. I'm doing that upon information and belief. I haven't run the scope. I know the state could do that, but I don't see that he has any felony convictions. He's made his appearances, and I think the time in jail has been. It's
a good argument to say he's made his appearances. That shows that he's likely to. I mean, the past isn't predictive of the future, but the past does set a pattern.
Shocking to him. I know it has, because I can tell the reaction of the calls every day and how different.
So essentially now he's arguing that jail sucks and Chilli doesn't like to be in jail. Like, I mean, call me crazy, but I think that's the whole point of it. Jail sucks. So don't go to jail. But once you've been convicted and you're sentenced to jail, jail will still suck. But like, is that really like a good argument for getting bail, for getting out of jail? it's an argument.
Difficult it is for him. I think he pushed this and is learning a very, very difficult lesson in life.
See, phrasing. You listen to phrasing. He is learning. Not he has learned. He is learning. Well, I mean, if he's still learning it, maybe the lesson should continue until he has learned his lesson.
I would ask the court to consider, based upon his ties to the community, sister here, nephew, he has a whole bunch of people who wanted to come to court, which I suggested may be a very, if they're going to come here, be respectful and mindful of what's already occurred in this court.
He has a bunch of people who basically want to testify on his behalf that he's a good person. He's a good boy who didn't do nothing. And he was just on his way to college when that mean cop jumped in his way and forced Chilli to have the interactions with him. But again, like, it's maybe I'm just a little jaded. I don't know. Maybe I'm jaded. But I'm asking myself, like, why are you telling the court that you had to tell Chilli's circle of friends that they have to be respectful in court? Most people know. You grab an average person off the street, you bring him into court. Number one, they're going to dress nicer than they normally dress. Doesn't mean they're going to be in a suit and tie, but generally speaking, without prompting, they will dress nicer than they normally dress. And number two, they will attempt, at least initially, to be respectful. Your average person off the street, in my experience, having sat in dozens and dozens, maybe hundreds now of hearings and things like that, like, so essentially he's saying that Chilli not only is an asshole who doesn't respect the court and authority and the law and the process, but his circle of friends and family are also assholes who are going to act similarly and similarly disrespectful. I'm not digging this so far. I mean, again, I just want to make it clear that this guy has 25 years of experience as a criminal defense attorney, and I am just a first-year family law attorney. What does he know that I don't know? I don't know. And again, he's got a raw deal here. He's been dealt this hand. He didn't pick it. So, I mean, he's got to argue something, but man, this sucks so far.
Well, what I asked the court to do, given his lack of any serious criminal history, his
again, so you start hearing the qualifications. His lack of serious criminal history, i.e., there's criminal history.
remorse for his behavior in this courtroom during that trial.
His remorse for his behavior in the courtroom during the trial, which is different than saying his remorse for the actions that he took with the officer and Jane Doe.
And the fact that the state at the time did not want jail time, is I'd asked for an appeal bond, Your Honor, so that the issue can be, these issues can be properly raised. And so with that, Your Honor, I asked for an OR. I would just say a reasonable bail. I would suggest that since he came to the trial, since he already has gotten a taste of what inappropriate behavior in a courtroom looks like and feels like, I would ask for a bail in the amount of $10,000 or $20,000. Appeal bond in the amount of $10,000 or $20,000. With that,
so I don't practice law in Nevada. It sounds like there's bail and an appeal bond. So the difference, an appeal bond is generally speaking, if I lose at on the appeal, you know, or if I don't prosecute the case on appeal, like if I set the matter for an appeal, but then I don't continue with it, then an appeal bond would be something that you would forfeit for not showing up, or maybe it would also be like the amount of the fines and stuff that you'd be expected to pay as far as the underlying conviction. And then the bail would be something that you would get back as long as you make your appearances. So he's asking for OR and then an appeal bond. So, And the appeal bond is pretty steep. I mean, $10,000 to $20,000 for essentially 2 misdemeanors is pretty. That's again, I don't practice law in Nevada. Maybe he knows something I don't know. It just seems like a lot of money. But then again, maybe he's also smelling how I don't know. He wants OR on bail. Maybe he knows something I don't know.
Your Honor, may I respond orally? Typically, pursuant to the Nevada rules of criminal practice, the state has 10 days to file an opposition, but this was placed on calendar very quickly. So I would ask for leave of the court to answer orally.
Okay.
I think I missed that.
Your Honor, may I respond orally? Typically, pursuant to the Nevada rules of criminal practice, the state has 10 days to file an opposition, but this was placed on calendar very quickly. So I would ask for leave of the court to answer orally.
Okay, so apparently the state didn't prepare an opposition brief. And so she's just going to give her opposition orally. Okay.
Okay.
Your Honor, I'm in receipt of Mr. Orum's motion for bail or any alternative for his own recognizance release. I would note that NRS 178.488 does make it discretionary upon this court whether you would allow bail pending appeal. Mr. DeCastro, there has.
Yeah, the municipal court, my understanding of the municipal court appeal to the district court is that it is basically mandatory that they give bail. Whereas the judicial court or the justice court appeal to the district court is discretionary whether they grant bail. So
Been a briefing schedule set before Judge Levitt in district court on the appeal, but it's not set to be heard until July.
that's actually not that bad. It's an appeal to a district court. The district court in Nevada is just the general jurisdiction court. It's where felonies get heard. I think their family law cases and stuff like that are also heard at the district court level. So it's not a court of appeals. It's a district court, but it takes appeals from the lower courts. Like in California, if you get an adverse judgment in small claims, you can essentially appeal it to the superior court, which is the court of general jurisdiction in California. But then with misdemeanors in California, if so, a misdemeanor in California is heard at the superior court, and then when you appeal a misdemeanor, that gets heard by the appellate division of the superior court. So it doesn't go up to the actual California Court of Appeals. It goes to a group of judges in the superior court that act as an appellate court. So it's a lower level court of appeals. The district court it does that function in Nevada for the justice court and the municipal court.
Discretionary, Your Honor, as with a lot of the bail settings in Nevada, it's discretionary.
Or at least that's my understanding of it, considering I don't practice law there, and my time spent perusing their statutes has been pretty minimal.
And the state would oppose this court setting of bail at this point. There seems to be this assumption that this court sentenced Mr. DeCastro to 6 months in the Clark County Detention Center just because of his conduct or his inappropriate conduct in court. I would venture to say.
See, at a certain point, all the bad acting that Chilli's doing would likely tempt the judge to become distracted by it. When someone is overacting like this in court, it can be distracting. Instead of listening to the attorney speak, because attorneys love to talk. They love the sound of their own voice, and they yammer on and on and on and on. And you can zone out and start fixating on someone overacting like this. So just in general, I wouldn't recommend it. Stand basically at attention. Yeah, don't do the fake trying really hard to cry thing.
Say that Your Honor presided over the trial where you found guilt beyond a reasonable doubt for both the obstructing a police officer and resisting a police officer. You saw his conduct in the body worn camera by the officer. And I would venture to say, and I would submit to the court, that the 6-month sentence that you imposed isn't simply for his behavior in court or his behavior to your marshals, but that it is an appropriate sentence placed upon the defendant by the court due to the charges and the evidence that you saw during trial.
So he could have been sentenced to 6 months each. Each misdemeanor charge carried a maximum sentence of 6 months. So he could have gotten up to a year. Her sentence was smack dab in the middle of what she could have ordered. I don't think it was excessive, but both counsel have kind of gone far afield. The issue in front of the court is whether or not DeCastro should get bail pending appeal. That's it. So the issues that they should look at are, how well established is he in the community? And how do you show how well established someone is in the community? Well, do they have family there? Like significant family, not like my uncle lives there. Do they have a job in the area that like ties them to the area? Do they own a house in the area? Again, that would tie them to the area. It would make it less likely that they would just pick up and run. Now, unfortunately for Chilli, he doesn't have, I know he spent a lot of time in Nevada. I think he alleged that he used to work as a male stripper, I believe. So I know he spent time there. I'm not entirely sure that his job as a male stripper is really something that's going to tie him to the community. I don't believe he owns property there. I don't believe he has family there, or at least not significant family. When I say significant family, I mean like, yeah, my kids go to school here. My wife and I live here. We go to church here. We're part of the community. Most people wouldn't want to just sacrifice all that and bounce, right? So Chilli doesn't have a lot going for him on that particular aspect. So his attorney should hammer on the, he's made every court appearance. He's been OR and he's still made every court appearance. He hasn't missed any court appearances for anything in the state of Nevada, yada, yada, right? That's what his attorney should hammer on about. What this gal should hammer on about is he doesn't have any ties here. And he hasn't shown any remorse here. He was proud of what he had done. He was proud to have committed the crime. And, the appeal indicates that he still thinks that he didn't do nothing, right? The appeal says, Your Honor, you effed up. I didn't do anything, which kind of says that I don't have anything to be sorry about because I didn't do anything. That's why I'm appealing. So she should hammer on about the no ties to Las Vegas. She should hammer on about the lack of remorse. She should hammer on about the warrants. That he's got those 2 warrants that everybody's all excited about in Ohio. She should hammer on about those because that does show that he has, maybe not in this jurisdiction, but in other jurisdictions, he's failed to make the court appearances. She should hammer on about his pending charge in the municipal court. He's done the same thing. This isn't a one-off. This is a, once is but twice is a pattern. Unfortunately for Chilli, the prosecution has a much easier argument on this particular one. And so again, that's one reason why I'm not really bashing on his attorney. You make the arguments you can make, and I don't think his attorney really had a good argument other than Other than Chili's made all of his court appearances. Really, that's it.
There's also been this claim that Mr. DeCastro has stayed trouble-free for most of his life. I would venture to say, yes, he does not have felony convictions. He does not have gross misdemeanor convictions, but he does.
No felony convictions, no gross misdemeanor convictions. Okay. I thought he had. What was the GHB one? That was just a misdemeanor. Quick chat, help me out. Didn't he have a GHB? It was deferred. Thanks, Pat Pants. Okay. All right.
Does have pretty consistent contact with law enforcement. He does have
pretty consistent contact with law enforcement. That's to put it mildly.
a warrant out of Ohio for a trespass.
Oh, all the people who've been hammering on about the words out of Ohio. There you go. There you go. It's a fucking minor point, but again, you throw all the spaghetti at the wall and you see what sticks. And so she should mention it. It's something that the court can consider. Yeah.
And I understand that's a piddly misdemeanor, however.
Yeah, I understand. That's a piddly misdemeanor. Yeah.
His warrant status. And he has a pending case in Las Vegas Justice Court for the very same offenses
Justice Court. I thought he had a municipal court case.
Las Vegas Justice Court for his warrant status. And he has a pending case in Las Vegas Justice Court for
She must mean the municipal court.
the very same offenses that the court heard during the trial here. As to the claim that, hey, there were issues before trial, there should have been First Amendment issues raised or briefed prior to, Your Honor, defense counsel was able to argue the First Amendment defense. Your Honor.
I don't understand what this has to do with the appeal.
Heard these arguments both during the trial and during.
See, you feel as an attorney, you feel like you have to address all the points raised by opposing counsel, even if they're like way off base, just in case it's like the one thing that it's the straw that breaks the camel's back or whatever.
Closing arguments. Mr. DeCastro, when he took the stand, raised them as a defense, but Your Honor held after listening to all of the evidence and applying the law, or found him guilty, regardless. This was not a First Amendment issue. The state stands by that. This was simply the defendant breaking the law, and he was sentenced.
I agree. I don't think it's a First Amendment issue. I really don't. Like, I believe strongly in the First Amendment, but he was given an order to back up, and he didn't back up. And don't give me the whole he backed up 2 feet. He didn't back up. He knew what the cop wanted. You know what the cop wanted. The judge knows what the cop wanted. If you want to play semantics with what a cop orders on the street, well, it's a losing argument. Playing semantics like with a contract, if you're trying to interpret a contract and you play semantic games, that's the perfect time to play semantic games, because every word that's in a contract has been poured over, probably by attorneys, and a decision was made to put it in. In the heat of the moment, a cop barking commands to get back up. You know what the fuck the cop wants. The judge knows what the cop wants. I mean, this isn't time. It's not time for semantics at that point. Unless you want to get the video of yourself getting arrested, unless you want the notoriety, unless you want the clickbait titles and the GoFundMe's, then yeah, play semantic games, win semantic prizes.
Accordingly for his behavior, it was a conduct, it was a consequence, an appropriate sentence imposed by the court to the defendant. And so we would oppose any kind of change or any kind of bail setting or an OR at this point. This is not a pretrial detention. This is not a pretrial, as Valdez-Jimenez was cited also in defense counsel's motion. Valdez-Jimenez stands for pretrial detention. Mr. DeCastro is no longer cloaked with the presumption of innocence. He has been found guilty beyond a reasonable doubt by Your Honor. And so at this point, I would ask that the 6 months sentence.
So that's interesting. It does, and it makes sense to me. I haven't read any case law or anything like that on it because, well, you're not paying me to do it. But it does appear that Nevada treats pretrial bail differently than appeal bail. So, again, it makes sense.
That you impose and that he remain in custody.
Mayor.
That's interpreter quit reading. Thank you.
Yes.
What did she say?
Mayor.
That's interpreter quit reading. Thank you.
Yes.
May I ask the interpreter to quit reading? Interpreter must have been there on another matter.
So the interpreter over there, yeah, Merrick speaking. Oh,
I was talking about
Oh, I'm
the
sorry.
interpreter. Yeah, go ahead.
Your Honor, the statute we cited is, in fact, just discretionary to you to determine on appeal, pending appeal, whether a bit of appeal bond can be issued. I hear the state, I reckon.
So that's what he just did there was a classic maneuver by counsel. If their case gets distinguished and they don't have an argument to undistinguish the case, essentially to rehabilitate it, the previous counsel, the prosecutor, said the case that they cited was a case for pre-trial bail, i.e., it didn't apply to this case, to this situation, because this situation is about post-conviction appeal bail. So then he doesn't. I mean, maybe he doesn't have a response. I'm going to guess he doesn't have a response because that's why he's going on now about, the statute gives the court discretion. Well, great. The court knew the court had discretion. The cases that he cited were inapposite. They didn't apply.
Recognize that you found him guilty. I'm not trying to in any way argue that. On appeal, there are legitimate issues. The court can see that, there are some First Amendment issues just from watching the video, things that a court could consider on appeal. And so that's the only.
Really? Can the court see that? Like, I don't know if the court can. Like, I've given it some thought, but nowhere did the cop say don't film. He did say don't talk to my detainee, but that I don't think that's necessarily a First Amendment issue.
Basis I'm bringing that up on. But given the fact that I think he really is contrite for what he's done.
I think he really is contrite.
I disagree. Have you watched the videos that have been posted since you've been incarcerated?
I'm in a murder trial.
Okay, so
I had a chance.
So he's gonna apologize to me in a minute, but that's not what he's saying on what he's publishing online in his phone calls from the jail.
Oopsie fucking doodles. The advice that I consistently give, not just on YouTube to people on YouTube, but to my own clients, especially if they're going through something like a DV or anything like that, is to shut the fuck up. Shut the fuck up. Shut the fuck up. Don't talk about your case. Don't talk on social media. Certainly don't make videos and post them on YouTube about what you've been doing. or what you think. Don't talk about the judge. Don't talk about opposing party. Shut the fuck up. Shut the fuck up. Shut the fuck up. I'm surprised the judge admitted that she was aware of it, but it doesn't really have any relevance to the bail. So I don't think it's well, I mean, just granting the bail is discretionary. It's not like she's making findings of fact. And him being contrite or not is, I mean, you can just tell by looking at him in court, he's not contrite. And he wasn't contrite at trial. She doesn't have to make any leaps of logic to try to make him or to try to believe that he is contrite after having seen his actions and demeanor at trial. You know, she's almost a full-grown woman. She probably knows a thing or two. She's probably been down this country road a time or two. But oof, nothing like driving that nail home by running your fucking mouth. Now, again, in Chilli's defense, it is very hard to give up a revenue stream. Chilli makes his money by making videos. Chilli makes his money by generating videos about how the system is corrupt, about how judges are dumb and corrupt, and about how he's a good boy who did do nothing and he's fighting for you. And I'm reasonably certain, considering the fact the man lives basically out of a van that he doesn't even own, if memory serves me correctly, that he's not rolling in money. He's not a rich man, is my understanding. So I can understand how he would want to keep those revenue streams going, especially right now where he's hot. You know, there's a lot of interest being generated in him. That's why there's 250 people watching me right now at ungodly hours of the night. It's because there's a lot of interest in him. So I can understand why he would really want to keep publishing videos about how the system is corrupt and judges are corrupt. The unfortunate thing is that it's really bad for him to do it. It's really bad for him to do it. Just like I told Aiden, Turtle Boy, to shut the fuck up. I mean, every person who I've ever been in contact with who's been in a stage of a legal proceeding, I've said, shut the fuck up. Just don't even. I don't understand why people can't. I understand Chilli's predicament, but I mean, he's paying for it with extra time in the pokey. He does. So again, I'm aware of how this ends because people can't shut the fuck up on my Discord. So I'm aware how it ends. But if I am not mistaken, in Nevada, if the Justice Court denies the bail, he can ask the district court for the bail. So he's going to get another shot at it. But remember, that costs him money. This Orem guy, I mean, if he has argued in front of the United States Supreme Court, he is not cheap. And he was just doing a murder trial. And murder trials, you don't do cheap. Because it's a murder trial. A court wouldn't even let me do a murder trial right now. They don't come cheap. And people are willing to pay because, you know, it's a murder trial. And there's a lot on the line. But Chilli's paying him enough that he's not doing the murder trial right now. He's working for Chilli. So, and Chilli can't be doing too bad if he was able to put up a $10,000 to $20,000 appeal bond.
That's not what he's saying at all. And are you aware that he has a trial pending in Las Vegas Municipal Court? He has a case pending in Good Springs Justice Court where he continues to make
municipal court and another justice court? Did I miss that?
And are you aware that he has a trial pending in Las Vegas Municipal Court? He has a case pending in Good Springs Justice Court.
So he has another case that I wasn't aware of? Oh my. Oh my.
Where he continues to manufacture situations where he'll get arrested.
So is the Good Spring Justice Court the same thing? Oh, his recent traffic snafu, the illegal U-turn, just so that he could go and argue with cops on the Meridian.
Your Honor, I recognize that's what he was sort of doing for a living, and this is.
Oh, Your Honor, I recognize it. That was sort of what he was doing for a living. Holy Jesus. Oh my God. Your Honor, I realized that my client was sort of doing criminal activity for a living. Oh, you got to play the hand you dealt when you're the attorney. I mean, I don't envy this guy's position. Oh, I got to back that one up. Let's hear what an amazing argument he's going to make on that.
Get arrested.
Your Honor, I recognize that's what he was sort of doing for a living, and this is, he's now being incarcerated.
Right.
And
So
He's now been in car. Your Honor, my client has spent like a whole 10 days in jail. he was essentially, my client was a career criminal. He was committing crimes for a living. Your Honor, he spent like 10 days in jail. He's a changed man. Look at him crying over there.
what he's saying in the couple of weeks since he's been incarcerated, when he calls from the jail and publishes them on his website, is not what he's about saying to me. Okay, so he's going to apologize to me now, but that's not what he's doing publicly. Okay.
He's going to apologize to me now, but that's not what he's doing publicly. Okay. And look at Chilli still trying. He's still trying hard.
yeah, sure, I hear that. I won't have him speak at this time, but
I won't have him speak at this time. Oh, fucking Christ. I distinctly remember at the beginning of this, no matter what the outcome of this hearing is, my client's going to apologize to the court. I'm not going to have him speak at this time. Good job, Chilli. Yeah, you effed yourself in the a-hole.
I would still ask you.
Chilli was pissing in his own shitter.
Yeah, sure, I hear that. I won't have him speak at this time, but I would still ask you to consider that there may be legitimate issues. I think there are for Judge Levitt to consider, and I think these are sort of issues of first impression. That was the other thing I saw, is that in the state of Nevada, I can't find any case law that specifically talks about this filming of police officers.
So let's just assume. Well, see, here's what he's doing. He's trying to argue the merits of the appeal because he's got nothing to fucking argue about on the bail. And again, I'm not going to go over the First Amendment issues, but that's why he's arguing like, oh, well, he might have a good appeal. He might have solid grounds for appeal on the First Amendment. No, he doesn't. No, he doesn't. Bartlett versus Neves says that if the cop has probable cause, he can arrest you regardless of whether or not you're engaged in First Amendment activity. That's been established since, 2019 or 2020? Unless he could show that similarly situated people were not targeted, and he'd have to do that to show that he was targeted. Like that. Chilli made this argument in his in the Las Vegas Municipal Police Department lawsuit. And there was a case in Nevada that was pretty on point. And it was where cop watchers, people like cop watchers, I don't know, they were chalking. They were writing in chalk on like sidewalks around, I'm going to say a courthouse. It could have been something else. I don't really know. Don't really care. But the fact is they were writing on the sidewalks in shock. And they were writing things that were anti-police. They were calling the police names, essentially, calling them pigs, blah, blah, blah. And they were arrested. Now, what they were doing, was it technically graffiti? Yes. But they could show, and they did show in their lawsuit, that other similarly situated people, like kids and other people who wrote messages that weren't anti-police, were not prosecuted. That's what you'd have to show. That's what Chilli would have to show. Essentially, he would have to show that people who interfered in traffic stops to say pro-police things or whatever were not arrested. But again, he wasn't arrested necessarily for the initial interference. He was arrested for refusing to back up. And by refusing to back up, I mean refusing to back up in this type of way that the officer and the judge and you and I expected him to, which interfered with the stop. And then the resisting was, the pull away later. But you get what I'm saying? Like, I just don't see a First Amendment issue. I really don't. And I don't see how you can say that there wasn't probable cause because, well, I mean, he's already been found guilty. So you've got the whole Bartlett versus Means. I don't know where you're going to go. I don't know where you're going to go on this.
What I would say to the court is I recognize that it's obnoxious behavior. That's what it appears to be. Whether it's protected is another thing that I think higher courts need to look at. But
you think higher courts need to look at it, and they will. But you're sunk. I mean, I don't know where you're going. I wish you the best of luck, but I don't know where you're going with this. I mean, you're gonna make your dollars. You're gonna represent your client. You're gonna fight for your client. I fought for my client, and you're gonna get paid. And you put the money in your bank account, and yay! But you're not going anywhere.
I can see if the court has already made up the court's manual.
Well, I want to be clear. I did not have a problem with him filming. And
If the court's already made up the court's mind, basically he's like, I'm not persuading you. I'm not persuading you, so I'll just shut up now.
I said that when I sentenced him. That was not the issue. It was the safety issues that he created with his behavior. And I also did not sentence him because of his ridiculous behavior in court. That wasn't why I sentenced him to jail. I sentenced him because I found him guilty beyond reasonable doubt, and I thought that was the appropriate sentence. I could have given him 180 days on each count and ran it consecutive for a year in jail, but I didn't. And his behavior was unacceptable in court, but that's not what I sentenced him for. I did not sentence him for his behavior in court. I sentenced him for his behavior for the 2 charges that he faced.
Yes, sure.
All right, so your motion is denied. Thank you.
Thank you.
Womp, womp, womp. Here's the end of it. No, there's no more. No, that's the end of it. All right. Anyway, it was real. It was fun. I wish I could say it was real fun. Thanks for watching. Have a great evening.